I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Form 8K. On September 26, 2016, and again on the 27th, the SEC brought enforcement actions against issuers for the failure to file Form 8Ks associated with corporate finance transactions, and in particular, PIPE transactions involving the issuance of convertible debt, preferred equity, warrants, and similar instruments. During a conversion process, the number of issued and outstanding shares of common stock can increase dramatically, causing dilution to existing shareholders and a decrease in stock price from large selling pressure. In an action against Connexus Corporation, the SEC noted that the unreported issuances of securities increased the amount of total outstanding common stock by more than 600% from the last reported number. The ability of an investor in a PIPE transaction to convert and trade responsibly makes the difference between a successful financing relationship with the investment community and one that can cause long-term damage to a company. To be clear, I do not think that there is anything inherently wrong, illegal, or improper with these corporate finance transactions. The exact same structure is used for PIPE investments in companies big and small, whether traded on the OTC markets, NASDAQ, or the NYSE. However, smaller companies, especially those on OTC markets, often do not have the volume and liquidity to bear the effect of sudden enormous selling pressure. Larger companies are not immune to issues, though. Nuanced provisions negotiated in these convertible derivative instruments can be problematic as well, such as the recent use of the Black-Scholes put option in warrants. Vapor Corp provides a prime case study example of what can happen when the financing provisions are not fully understood and vetted by the parties. Vapor Corp lost its listing on an exchange as a result of such a PIPE transaction. When considering a PIPE transaction, companies are often presented with numerous term sheets and investors to choose from. The terms will only vary slightly, and many investors will match terms from a competitor. In choosing a transaction, it is incumbent upon the company to conduct due diligence on the investor, including their reputation in the industry and trading history associated with other investments and conversions. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.